Good day and welcome to Clean Slate, Streamlining the Expungement Process. My name is Casey Payton. I run the Virgin Islands Justice Initiative. Um, the Clean Slate program was the very first initiative of the Virgin Islands Justice Initiative. We've been around for 2 years now. We are a nonprofit 501c3 legal aid organization here in the Virgin Islands focused on economic justice and poverty law. Let's dive right in. What is Clean Slate? Clean slate laws across the nation are also known as second chance laws, and they are laws that expunge or seal criminal records, arrest records. And in the mainland, there is usually a waiting period, and expungement is typically carried out for misdemeanors and some low-level felonies. The public policy benefits. So this is what we are all in it for. Clean slate policy aims to give people a second chance, especially those who were unfairly targeted to begin with. Over time, laws can change what we focus on when it comes to crime and intervention changes. And so clean slate policy provides the Virgin Islands with an opportunity to revisit some of those laws and how they're affecting our community. And what an expungement does is it removes incidents from your criminal record so that you can be judged for the person that you are now and not the person who you were in the past. Let's start with the ABA policies. ABA policies mostly focus on collateral consequences, reducing the impact of collateral consequences of convictions and reentry. On the ABA's website, there are several different things that the ABA focuses on. They focus on, current legislation. They have their own policies, and when you look under their definitions and objectives, they have a really good definition for collateral consequences, which they sometimes refer to as collateral sanctions. And I go into it more in the next slide, where under the ABA's policy, collateral consequences of criminal convictions, also known as collateral sanctions, are legal penalties that take away rights, access to programs or services, or that impose other types of disadvantages that punish but are not part of that person's sentence. And so here in the Virgin Islands, that plays out a certain way. Nationally, different states do it different ways. I want to focus more on what that means here in the Virgin Islands, but I think it is important for us to look at what is the ABA saying about this? Why does this matter to them? Why are they focused in on collateral consequences? I thought this part was really important from their policies, that when properly administered, collateral sanctions can play an important role in achieving legitimate objectives, clearly. But then many times people are given incentives to plead guilty without maybe being notified of the collateral consequences of doing so. And then many of these added sanctions bear no relation to the underlying offense. And then they undermine both an individual's reintegration into society, that reentry into society, and public confidence in the justice system. The ABA focuses in on voting. And so in the case of voting, the ABA says there's no rational basis for taking away the right to vote, for refusing to reinstate it upon a person's release. That the ABA takes a strong position on voting. When it comes to the path to reentry, the ABA does think it's important to have clean slate laws. One of the ABA's objectives is to facilitate reentry into society and reduce recidivism by limiting situations in which a convicted person may be disqualified from otherwise available benefits or opportunities. And so the way that we think about this with the VI Justice Initiative is that we kind of try to focus on what are the economic consequences of of these laws. And so if there's something that is standing between a person's ability to earn an income, to qualify for housing, to pursue their education, these are policies that we look at. So let's jump right into where is Clean Slate in Virgin Islands law. And luckily for attorneys, it's just one section of the law. And so um, it's not too dense. It's not too hard to become competent in expungement. And so under Title V, Virgin Islands Code, Chapter 314, that's where you find everything that you need. And I actually pulled this for you. I think it's helpful sometimes in the code to look at the table of contents. And so you can see how this section, it starts with the definitions, it goes all the way down. It's not too many sections, like I said, to read it, to get competent in it. And I think it's also very easy that if you only focus on criminal defense, or if you're only focusing on civil, you might miss some of the pieces. And so I think that this is also really important for criminal defense attorneys to see, okay, well, now that, if you're talking with somebody about a potential plea, it is important to understand what they may have to go through if they want to get, for example, a misdemeanor conviction expunged, to go through the process. And this is where you would go to find out what is the process to go through to file a petition and what all of that entails. I'm going to give you guys the easy version of this. So we're going to talk about some examples where expungement is required, and then some examples where expungement is possible, but it's not required, because there's actually a lot of different situations where expungement is required. I think people just aren't really aware of it. Even as attorneys, we might not really be aware of it. And so let's go down the list. So first of all, if your client completes the pretrial intervention program, the PIP program, at that point, as soon as that order is in that says that there was a successful completion of the pretrial intervention program, that person is not only eligible to file their petition for an expungement, but they have the right to that expungement. It is required. The next one is where there is a statement of no prosecution by the Attorney General's office, precisely because the people are unable to meet their burden of proof. If that's the reason for the statement of no prosecution, then that person is now eligible. Now, if it's a statement of no prosecution, that it's not because the people are unable to meet their burden of proof, I guess that's a different situation, then you have to wait for the statute of limitations to actually expire. And so you have to look at, what is the statute of limitations for a misdemeanor charge? What is the statute of limitations for a felony? And then once that time has passed from the date of the arrest, then you can file that petition for an expungement. The next time is an arrest with no charging document, and the statute of limitations has expired. So what does that mean? That means that yes, the person got arrested, but it never got to the point where a charging document, a complaint for a misdemeanor, or information for the felony, it was just never filed. And so the case was dropped. A lot of times people in the community think, okay, my case was dropped or it was dismissed, it goes away. No, it doesn't go away. It doesn't go away until you actually file that petition for expungement and go through that process. But it is important that an individual know that, okay, at this point, the people decided not to move forward. There was no charging document. There was no information or complaint. And so once you reach that statute of limitations, then you can go ahead and file the petition for expungement. The other ones are when a case is dismissed. Of course, it matters, how was it dismissed? Was it dismissed with prejudice, or was it dismissed without prejudice? If the case was dismissed with prejudice, and there are no other charges or arrests pending, then that individual can file their petition for expungement. Now, if a case was dismissed without prejudice, then you have to wait for that statute of limitations to run. And that can be a hard pill to swallow sometimes for clients, where they think, okay, the case is dismissed, let me get this off the record. But no, you're going to have to wait because, as your attorney should explain to you, the people still have the ability to bring this case back throughout the statute of limitations. Now, an example of where the court may expunge records. So, here in the Virgin Islands for misdemeanor convictions, the statute is really narrow. It doesn't allow for expungements of felonies. It's really just that first misdemeanor conviction. Because as I like to say, and as my mentors ahead of me said, this is a second chance law. It's not like a third, fourth, or fifth chance law. It's really that first misdemeanor conviction, where the Department of Justice then has the burden of proving by clear and convincing evidence that the petition for expungement should not be granted. Now, if that happens, if the Department of Justice doesn't object, which they do in many cases, then it is a situation where the court shall grant the petition for expungement. So the burden is on the Attorney General's office at that point. Wait to see, what their response is. The law has changed within the past 2-3 years. And so the first thing that I want to address is about the automatic expungement when no probable cause is found. And these two changes in the law, I have to give a lot of credit to Attorney Key Walker as the architect in her pro bono capacity, for really helping the Virgin Islands move forward and streamlining the expungement process. So there was a situation before this law was passed earlier this year, 2024. Before this law was passed, if a person was arrested and they went to advice of rights, if the police officer was found to not have probable cause for that arrest, for that charge, it would be a situation just like if a case was dismissed and the individual who was arrested would have to wait the full statute of limitations before they would be able to file a petition. And that just wasn't sitting right. That felt a little bit unconscionable, unconstitutional. If you didn't have probable cause for the arrest, that person still had to be in a situation where they were denied certain, as we would say, they it was an economic justice issue, right? They wouldn't necessarily be able to go into a job and have a clean background check. That would be on their record. And if that individual, even though the police officer didn't have probable cause for the arrest, if that individual wanted to get that arrest taken off their record, they actually had to go through the process of filing the petition and waiting for a court to grant the order for the expungement. And it just doesn't sit right ethically, or maybe morally in the Virgin Islands. And the legislature agreed. It wasn't a challenging policy to get through. But now, when the court finds that there's no probable cause for an arrest, the court shall simultaneously enter an order expunging the arrest record. And I do believe that this piece of legislation is really good quality legislation. It went through several different offices, including the Office of the Territorial Public Defender, for feedback. And it was just kind of a missing piece in order to streamline the expungement process. The other bit of legislation that passed 2 years ago, so it passed in 2022, I believe the governor signed it at the beginning of the following year. This was the one that had to do with marijuana related convictions. And this one, once again, credit attorney Key Walker as the architect. And it was a little bit challenging just because the community's perception when it comes to marijuana related arrests and convictions has kind of changed over the years. And so whereas in the past there was this tough on drugs, say no to drugs, and policy of arresting lots of Virgin Islanders for having simple possession of marijuana. Since that is moving towards being, decriminalized in the Virgin Islands, it made sense that at the same time, people who have been impacted by the collateral consequences of marijuana related convictions also receive some relief. And so remember that there already is a path in the Virgin Islands for a misdemeanor conviction to be expunged. It's not a mandatory, but it's a possibility. But this piece of legislation and this statute expands that. And so this now makes it more of a mandatory, right? It's mandatory, and it should be the auto expungement of conviction or an arrest, where the crime outlined was possession of 2 ounces or less of marijuana. It's worded a little bit tricky, just because it kind of like clearly for a misdemeanor, simple possession of marijuana, that can come off. But it's a little tricky about whether it kind of also may apply to some felonies. And that policy work is still being done by the governor's auto expungement task force. The auto expungement task force has been charged with one, coming up with a policy, a process for auto expungement for marijuana related convictions. But the other piece is the policy piece about whether the task force has any recommendations about whether the ability for an individual to obtain an expungement for a marijuana related conviction should be extended beyond just simple possession of marijuana. And so that task force has some difference of opinions about that. But there is a good possibility that it will be expanded a bit to possibly include some felonies that are marijuana related, but that's yet to be determined. When it comes to streamlining the expungement process, there are some policy considerations that the community, that lawmakers, that attorneys should take into consideration. Number one, that this is an access to justice issue. Just because somebody has the right to get their record expunged doesn't mean they have the ability to do it. Um, it's been great over the past couple of years that so many parts of litigating in the Superior Court that attorneys have been able to file electronically, and it's made it a little bit simpler for attorneys. I don't know if it's made it simpler so much for pro bono, pro se, pro se clients. But as far as access to justice, it can be kind of challenging for somebody to obtain an expungement because that process is a court process where, a petition has to be filed, the Department of Justice has to be served. There isn't a rule, well, the rule has not been updated yet to allow for that initial summons to be served electronically. And so that can be a hurdle and an expense. And then getting that petition through the process, whereas an attorney, it's not a huge lift to be able to do a petition for expungement. For a pro se individual, it can be very, very confusing. And a lot of people get stuck at various parts. One of the parts that people get stuck at is that there's a packet at the Superior Court that shows somebody how they can file a petition. And that packet, maybe it hasn't been updated to include the misdemeanor convictions. And so if you look at the packet and you read the packet, there wouldn't be any way for an individual to know that their misdemeanor conviction could be expunged. And so perhaps people see that and they just stop and they don't go through the process. Another thing is that if they start the process with a petition, but the petition's maybe missing something, there is kind of a bit of paperwork that has to go along with it, different VIPD records and other, certified court documents that have to be filed along with it. And if something's missing, it can be a little bit confusing for a pro se petitioner to figure out what exactly it is that they're missing and how do they fix things. So that access to justice piece, we see at our organization, at the VI Justice Initiative, that if somebody was able to get the expungement, like they probably would have already done it. It really is serves as a detriment to their ability for like economic prosperity and social mobility. And so being able to make that process a little bit easier, or for attorneys to just volunteer and help out, or consider taking cases at maybe a low cost, that would assist in the process. The workforce development piece, and maybe I should go on to the next slide, because it goes along with the collateral consequences in the Virgin Islands, where these are the things that hold people back. And it does have to do with workforce development in the VI. And so a person's ability to access gainful employment, once somebody has something on their record, a lot of times they hold on to their job very dearly, if they have one, because a lot of times you don't feel like you have that social mobility or ability to change jobs, because you're worried about your record showing something that is going to make that employer not hire you. Or if you are not in the, you're not participating in the economy as a taxpayer, maybe you're doing more like manual labor on the black market, it may deter you from actually applying for jobs where you could become a taxpayer, because either in your experience or you're worried that somebody's going to say that they don't want to hire you because of your record. Access to housing is a thing, because people run background checks and because there are certain federal regulations pertaining to records and whether you can access certain housing benefits. Education, you can lose scholarships. In the past, you could lose federal funding for marks on your criminal record, arrests. And at the end of the day, a big part of it is the character judgment. We're in a very small community, and when somebody knows that you have this on your record, like it affects your reputation. And a lot of people at the end of the day, they want this removed off of their record because they want a chance to be seen as the person they feel that they are now. They a lot of times people want to be seen as, that they've changed. The person who they were when they were younger, who was getting into trouble, that they're no longer that person anymore. They've matured. They've shown that they can be a productive member of society and they can be responsible. And so this is part of, honestly, taking responsibility for their past and attempting to be seen in a different light. This is some very strong testimony from earlier this year when the VI Justice Initiative was asked to testify about the auto expungement legislation for when the judge finds no probable cause for the arrest, whether that mark on your record should be expunged automatically. And at the VI Justice Initiative, we saw it as in this light, I'd like to share. So we testified that we believe that it is unconscionable that Virgin Islanders have to keep charges on their arrest records forever, simply because they are too poor to afford an attorney to assist with this process. We do believe that it is a racial justice issue, and you might have seen on the previous slide that there are notes of, the need to alleviate the burdens on the vestiges of colonialism, because expungement services are so widely available free of charge on the mainland. That feels like the inequality, because here in the Virgin Islands, where we have a population that is majority Black, these records continue to hold Virgin Islanders back from economic and social mobility forever. Once something's on your record, if you don't go through the process of filing the petition, going through the expungement process, that mark is going to be on your record forever. And there's a deep unfairness that if you had been arrested in the States, you might have assistance to get that taken off, but not here in the Virgin Islands. I want to thank you for listening to this CLE presentation today on Clean Slate. I want to thank the attorneys who assisted with building out the Clean Slate program, Attorney Russell Pate, Attorney Key Walker, who provided their sample documents and so much mentorship to get it off the ground. This is still a new program, just slightly more than a year old. If you know anybody who believes that they would like to have their record expunged or would like to talk to somebody about the possibility of getting their record expunged, send them to the Virgin Islands Justice Initiative. Our phone number is 340-774-6504. We will provide full legal representation for anyone to obtain an expungement if they're eligible under the law in the Virgin Islands. And we're only able to do this because we have so much support in the community. We have pro bono attorneys who are willing to help. We have a volunteer retired legal secretary who is absolutely phenomenal. And we appreciate you guys getting the word out that we're willing to help. And so if you'd like to be part of that, we'd be happy for you to assist us. Our goal this year is to reach 50 expungements, and we are well on our way to obtaining that goal in 2024. If you have any questions about the Virgin Islands Justice Initiative or how you can get involved, once again, our number is 340-774-6504, or you could reach out to us at info@vijustice.org. Thank you so much and have a great day.